The American people as trustees in bankruptcy over the United States post-1933 abstract. The 1933 cessation of the United States gold standard marked a pivotal restructuring of the national economy. The American people, arguably the primary creditors, were implicitly positioned as trustees in bankruptcy for the United States, a corporate entity distinct from the sovereign constitutional republic. This article explores the legal, historical, and economic implications of this arrangement, analyzing the roles of general creditors, secured creditors, lien creditors, and representatives of creditors in the broader context of national insolvency. We examine the fiduciary duties of the American people and consider the legal mechanisms that underpin their trusteeship. Introduction. The transition of the United States from a gold-backed currency to a fiat system in 1933, under Executive Order 6102, fundamentally altered the nation's financial structure. By declaring a national state of emergency and confiscating gold, the federal government effectively acknowledged insolvency under traditional economic definitions. The United States' obligations to its creditors, domestic and foreign, necessitated a reorganization of its debts and responsibilities. Within this framework, the American people have been rendered trustees in bankruptcy, tasked with managing the nation's liabilities and ensuring the solvency of its de facto corporate entity. Legal framework of trusteeship. Under the Bankruptcy Code, trustees act as fiduciaries responsible for managing the estate of the debtor in the best interest of the creditors. In this case, the United States, as a corporate debtor, owes its obligations to several categories of creditors. 1. General creditors. These include individuals and entities holding unsecured claims against the government. The general public, whose labor and taxes fund government operations, arguably falls into this category. 2. Secured creditors. These are entities with claims backed by collateral, such as international banks and foreign governments holding U.S. Treasury bonds. 3. Lien creditors. Those with statutory claims against specific assets of the government, including judgment creditors and claimants under tax liens. 4. Representatives of creditors. Trustees in bankruptcy, assignees for the benefit of creditors, receivers in equity, and executors or administrators of estates represent the collective interests of the creditors. The role of the American people. By virtue of their labor and the tax revenue they generate, the American people are de facto general creditors and simultaneously trustees tasked with overseeing the financial restructuring of the United States. Their role as trustees derives from the legal fiction of the United States as a corporate entity under 28 U.S. Code Paragraph 3002-15, which defines the United States as a federal corporation. This duality places the American people in a unique fiduciary relationship with the government and its creditors. Historical context. The establishment of the Federal Reserve in 1913 and the subsequent abandonment of the gold standard in 1933 were crucial developments in this transformation. The New Deal's economic policies, designed to address the Great Depression, effectively collateralized the labor of the American people and their future productivity. The Social Security Act of 1935 further entrenched this arrangement, creating a system of federal identification and financial tracking that linked individuals' earnings to the repayment of national debt. Fiduciary duties and responsibilities. As trustees, the American people shoulder several fiduciary responsibilities. 1. Duty of care, ensuring that government policies and expenditures align with the broader public interest. 2. Duty of loyalty, advocating for policies that prioritize the needs of the general population over the interests of secured creditors. 3. Duty of accountability, holding government officials and institutions accountable for fiscal mismanagement and advocating for transparency in financial dealings. Challenges to trusteeship. The primary challenge lies in the American people's limited awareness of their trusteeship role. The legal and economic complexities surrounding this relationship are seldom addressed in public discourse. Moreover, the government's reliance on fiat currency and deficit spending exacerbates the nation's insolvency, placing additional burdens on taxpayers. Comparative analysis with traditional bankruptcy. Traditional bankruptcy proceedings involve a clear delineation of roles among the debtor, creditors, and trustee. In the case of the United States, these roles are conflated. The government acts as both debtor and representative of creditors, while the American people serve as unwitting trustees and general creditors. This conflation creates conflicts of interest and complicates efforts to achieve financial solvency. Conclusion: the American people's role as trustees in bankruptcy over the United States is both a legal reality and a profound responsibility. Recognizing and embracing this trusteeship is essential for addressing the nation's fiscal challenges and ensuring equitable outcomes for all stakeholders. Through education, advocacy, and active participation in governance, the American people can fulfill their fiduciary duties and chart a sustainable path forward for the nation.